Welcome to this Queensland Ombudsman presentation for councillors. Complaints, human rights and PIDS, what every councillor needs to know. The objectives of this presentation are to provide you with information about four important topics, namely the role of the Queensland Ombudsman, the local government complaints management framework, the need to have regard to specified human rights in your decision making, and the nature of public interest disclosures, or PIDS. During the presentation, we will identify further resources that councillors and council officers might find useful. We will now look at the role of the Queensland Ombudsman. Who are we? The Queensland Ombudsman is an independent statutory officer of the Parliament and accountable to the Parliament under the Ombudsman Act of 2001. No person can direct how our investigation should be conducted, whether we should or should not investigate particular complaints, or the level of priority we give to investigations. The only exception is where Parliament or a parliamentary committee refers matters to us for investigation using a section of the Ombudsman Act. The Office of the Queensland Ombudsman has three main roles. Firstly, to give people a timely, effective and independent way to have administrative actions of agencies investigated. This includes receiving and responding to complaints that also allege breaches of human rights. Secondly, to improve the quality of decision making and administrative practices in government agencies. This includes the provision of training services and advice and reviewing the procedures and practices of agencies. And thirdly, oversight of the Public Interest Disclosure Act of 2010. This includes the provision of advice, the issuing of standards, and reviewing policies and practices. What do we do? Under the Ombudsman Act, we have the power to investigate the decisions and actions of local councils, including councillors and committees, and of state government departments and agencies, including state schools, TAFEs, and public universities. We can make recommendations to fix unfair decisions, actions and services in accordance with our Act. This includes decisions or actions that are contrary to law, are unreasonable, unjust, oppressive, or improperly discriminatory, the failure to make a decision or take an action, decisions or actions based on a mistake of law or fact, taken for an improper purpose, irrelevant grounds, or having regard to irrelevant considerations, or failing to take relevant circumstances into account. We are an independent complaints handling or review agency. We are not an advocate for a complainant, nor do we represent the interests of councils. Our complaint investigation service is free and confidential for everyone. Some examples of topics we receive complaints about each year are set out in this slide. Common themes relate to the unreasonableness of decisions to refuse a service or subsidy, problems with the way applications have been handled, the unfairness of decisions to exclude people from programs or services, decisions about the levying of fees or charges, failure to properly consider circumstances in relation to enforcement actions, policies or procedures that are unfairly discriminatory, and the conduct of public officers. The majority of complaints we receive about councils each year mirror their activities and relate to the enforcement of local laws, rates and charges, environmental management, and planning approvals or refusals. In the 2018-19 reporting year, councils accounted for just over a quarter of all complaints we received. Other statistics of interest were that 11,676 people contacted the office for assistance about a complaint. 4,540 public sector officers across the state took part in Ombudsman training sessions, a record level of participation, meaning that the office delivered 247 training sessions to councils and state government agency staff, and of these 96 were delivered regionally. The office finalised 7,831 complaints and closed 1,255 investigations. The preliminary assessment of complaints was completed in an average time of 3.3 days. The office also participated in 54 community engagement activities. We will now look at the complaints framework applying to councils. All Queensland government agencies and councils are required to have a complaints management system or a CMS. We require members of the public with a complaint to have exhausted the CMS of a council before bringing their complaint to the Queensland Ombudsman for assessment. The CMS requirements for councils are contained in the Local Government Act of 2009 and the Local Government Regulation of 2012. Section 268 of the Local Government Act requires councils to adopt a process for dealing with what are called administrative action complaints. Accordingly, the complaint management system of a council is also commonly referred to as an administrative action complaint process. The regulation requires the process must be supported by policies and procedures and cover all administrative action complaints, effectively manage complaints from receipt to resolution, and require responses to complaints to be quick, efficient, fair and objective, include assessment criteria and require complainants to be informed of decisions and reasons for complaint outcomes, ensure mechanisms are in place to identify, analyse and monitor complaint trends and monitor the effectiveness of the process, require regular reporting to senior management about the operation of the process. The purpose of a CMS is to assist council and the public to resolve issues. Having the process visible and available on websites and displayed in council offices assists in setting and managing complainant expectations in relation to how complaints are going to be managed by council. A well-functioning CMS provides a valuable conduit to assist councillors in ensuring fair and efficient handling of issues raised by people in their community. An administrative action complaint is defined in the Act as a complaint made by an affected person about a decision or failure to make a decision. This includes a failure to provide a written statement or reasons for a decision, an act or failure to do an act, the formulation of a proposal or intention, or the making of a recommendation. This is a broad definition which mirrors the definition of administrative action in the Ombudsman Act of 2001. It includes the administrative actions of council committees and those made in council chambers. Section 306 of the Local Government Regulation provides further clarification of the definition by declaring that in deciding if a complaint is an administrative action complaint, it is irrelevant how quickly the complaint was resolved, to which area of a local government the complaint was made, whether the complaint was a written or verbal complaint, and whether or not the complaint was made anonymously. Section 187 of the Local Government Regulation places public reporting obligations on councils. Council is required to include certain information about the complaints process in its annual reports, including statements about council's commitment to dealing with complaints fairly and how council has implemented and assessed the effectiveness of their CMS. The number of complaints received, resolved and not resolved during the financial year, and the number of complaints received in the previous financial year that remain unresolved. The Council CMS should provide guidance on how complaints will be received, including Council's preferred methods for communicating with complainants. However, the broad and varied nature of council business creates a multitude of communication channels that may be used by the public. All contacts should be properly assessed to determine if they constitute a complaint or are something else, such as a request for a service or the provision of information. Where a contact is assessed as meeting the definition of an administrative action complaint, it should be referred into the CMS of Council for handling in accordance with Council's approved processes. It is also common for councillors to receive such contacts. All contacts should be assessed and handled in the same way. Council complaint management systems should provide a three-stage process for handling complaints. Firstly, a frontline early resolution stage. This is usually by the business area responsible for the subject matter of the complaint. It may involve two stages of complaint handling, by staff, then management. The second stage is an internal investigation or review stage. This is usually conducted at a higher level, such as by the CEO's office and by staff with no previous involvement with the issue complained about. This may be Council's last opportunity to resolve the matter before a complainant takes the issue to an external body, like the Queensland Ombudsman, for review. And finally, there is the external review stage. This is conducted by a relevant external agency with jurisdiction to consider the complaint issue, such as the Queensland Ombudsman. People may be unsure where to take their complaint. Councils often have a concurrent jurisdiction and service delivery role with other agencies, for example in water supply, environmental regulation, planning and health. Occasionally, councillors may have contact with people seeking assistance with issues that are not the responsibility of council, and they may want to refer that person to another entity. Councillors wishing to assist constituents to resolve their issues should be aware that there is a broad network of complaint handling organisations at both the state and Commonwealth level. This slide identifies some of the larger complaint bodies and their jurisdictions. If you are unsure about which complaint body is best placed to assist a constituent, you can go to the Queensland Ombudsman website at www.ombudsman.qld.gov.au and look for information about other complaint handling organisations. We will now look at human rights in decision making. The Human Rights Act 2019 is an important new piece of legislation that needs to be factored into all discretionary decision making. The Human Rights Act applies to all government entities in Queensland, including councils. The Act commenced on the 7th of March 2019. The Act established the Human Rights Commission, formerly known as the Anti-Discrimination Commission, or the ADCQ, from 1 July 2019. The public complaints function under the Act, which allow members of the public to make complaints about a breach of specified human rights, commenced on 1 January 2020. The Human Rights Commission has oversight of both the Human Rights Act and the Anti-Discrimination Act. The Queensland Ombudsman is a referral agency and as part of carrying out the office's functions will be examining council's decisions, actions, policies and procedures for compliance with human rights obligations. The Human Rights Act is an act that respects, protects and promotes the inherent dignity and worth of all human beings, especially the most vulnerable in our community. The aim of the Act is to embed respect for human rights in the culture of the Queensland public sector and ensure that public functions are exercised in a way that is compatible with human rights. The Act requires all of us to think about the way a person's human rights may be affected by the decisions we make, from policy development to day-to-day work in the community. A human rights approach should now be becoming business as usual for all councils, meaning fairer laws, policies, practices and service delivery for the community. Only individuals have human rights. Human rights will need to be identified and considered when developing and reviewing laws and policies, in the delivery of actions and discretionary decision making, and when handling complaints. The creation and maintenance of records will be vital to show progress in achieving compliance with the Human Rights Act and to demonstrate how any limitations on human rights have been justified. Similar to a code of conduct, the human rights model adopted provides a perspective to guide how councils should go about developing and interpreting laws and making decisions and taking actions. It is known as a dialogue model, to assist the three arms of government to talk and work together to ensure the rights of the individual are properly respected and promoted when decisions are being made. The Human Rights Act is not a constitutional Bill of Rights, nor is it an instrument to encourage litigation. When new legislation is being considered, Parliament will be required to consider compatibility with the specified human rights contained in the Act. Laws limiting human rights may still be made, but will need to be justified. Courts and tribunals are required to interpret laws to the extent possible that is consistent with their purpose in a way that is compatible with human rights. The rights set out in the Human Rights Act are drawn from international conventions. Some of the human rights contain a number of elements setting out several rights. There are 23 sections containing rights in the Human Rights Act, although some sections specify more than one right. These are not the only rights held by individuals. They are in addition to any other rights and freedoms, such as those already confirmed by other legislation. It's important to note, though, that the human rights protected under the Act are not absolute. They may be balanced against the rights of others and public policy issues of significance. There are provisions under the legislation which allow this balancing to occur. Also, the Act does not invalidate any legislation, nor does it stop a law that may be incompatible with human rights from being enacted by Parliament and enforced by the public sector. The Human Rights Act places obligations on councils and all public entities in Queensland. Those obligations mean that it is unlawful to act or make a decision in a way that is not compatible with human rights. and in making the decision to fail to give proper consideration to a human right relevant to the decision. Section 8 of the Human Rights Act provides the meaning of the phrase compatible with human rights. It means an act, decision or statutory provision is compatible with human rights if the act, decision or provision does not limit a human right or limits a human right only to the extent that is reasonable and demonstrably justifiable in accordance with Section 13 of the Act. When decision-making is discretionary, a human right may only be reasonably limited when it can be demonstrated that the limitation is justified. Good record keeping will be needed to provide such justifications. Section 13.2 of the Human Rights Act provides the framework for deciding whether a limit on a human right is reasonable and justifiable. This test is sometimes referred to as the proportionality test. Factors to be considered are the nature of the right, the nature of the purpose of the limitation, the relationship between the limitation and its purpose. In other words, does the limitation help achieve the purpose? Is there anything less restrictive and reasonably available that can or should be done? And requires a weighing up of the importance of the purpose of the limitation versus the importance of preserving the right. This slide illustrates the basic model for assessing compatibility of decisions and actions and requires councils to identify all rights relevant to the decision or action, consider if council's purpose for limiting any rights is legitimate and consistent with the principles of freedom, equity and dignity. Consider whether the proposed decision or action will achieve this purpose. Consider if other options are available that may achieve the purpose with less limitation on the relevant rights, and weigh up the balance between any limitations on the rights and the importance of the purpose. The Human Rights Commission website, www.qhrc.qld.gov.au, contains a number of guides and fact sheets and offers online training which will assist in providing a more detailed understanding of the processes for identifying relevant human rights and assessing the impacts of decisions and actions. It should be noted, however, that councils have always been required to carry out their functions and deliver the services in a way that is fair and reasonable and that best serves the public interest. Since 1974, the Queensland Ombudsman has always been required to assess whether a complaint suggests that particular decision-making is unreasonable, unjust, oppressive, or improperly discriminatory. The assessment of complaints requires us to identify and consider the circumstances of individuals, many of which relate to human rights. The Human Rights Act simply identifies and codifies some of the circumstances to be factored into government decision-making and now provides a framework to assist in protecting those rights by ensuring those circumstances are properly identified and considered. There are a number of human rights hotspots in decision-making. Record keeping. Records will need to be kept in order to demonstrate human rights were identified and any limitation assessed for reasonableness and then justified. Decision-making power. Powers may only be exercised in a way that is consistent with the rules applying to the particular power. The Human Rights Act applies where decision-making may impact upon the rights of individuals. The existence of discretionary power should be a trigger to assess if human rights may be impacted. Key issues. Decision makers are required to identify matters relating to the person's circumstances, which may need to be considered in order to identify relevant human rights and to determine if these rights may be limited. Gathering all necessary information. When gathering information, agencies will need to consider whether their practices may limit the right to privacy and reputation. Application of the law. Section 48 of the Human Rights Act requires that all statutory provisions must, to the extent possible that is consistent with their purpose, be interpreted in a way that is compatible with human rights. Reasonably exercised discretion, requiring consideration of all relevant circumstances. And finally, giving meaningful and accurate reasons, explaining human rights have been considered and any limitations have been justified. This is a new and evolving area of law in Queensland. We appreciate that many councils are still working to develop their capacity to more fully factor human rights into the decision frameworks. For more information on human rights, these links will be useful. We will now look at our final topic, public interest disclosures. What is a PID? People generally know when something is wrong or when another person in their organisation is not doing things the way they should be. The Public Interest Disclosure Act, or PID Act, provides a way for people to disclose information about serious wrongdoing in the public sector and to ensure they are appropriately protected when they do so. Councillors and all public officers should be aware of the PID Act. Councillors can make PIDs and receive them. The PID Act is an important part of the integrity framework within the Queensland public sector. The Ombudsman is the oversight agency for the PID Act and has a range of responsibilities, including providing advice and assistance to agencies so they can identify disclosures and support and protect the people who make them. The PID Act applies to state government departments, including state authorities and universities, local governments, and to a limited extent government-owned corporations. The PID Act provides a way for people to disclose information about serious wrongdoing or danger and to ensure that they are appropriately protected when they do so. Importantly, a complainant does not have to declare that their complaint is a PID or request protections in order to be protected by the PID Act. It is up to the agency to identify a PID and to action it accordingly. People who report wrongdoing are doing the right thing because wrongdoing such as corruption and maladministration increases the cost of providing public services and harms the reputation of the agencies involved. Alerting organisations to wrongdoing provides senior officers with an opportunity to fix the problem, and it is certainly in everyone's interest that dangers to public health and safety or the environment are dealt with quickly. What makes a PID? In simple terms, a PID is a particular and special characterisation of a complaint or information received. Three concurrent elements come together to make a PID. Firstly, there must be an appropriate disclosure. Secondly, there must be certain types of public interest information. And thirdly, the complaint must be made to a proper authority. Disclosures are PIDs when they meet the test under the PID Act. PIDs are in the public interest, not a complaint that can be withdrawn once made. PIDs may be involuntary, for example, information you are legally required to disclose. For example, auditors may make PIDs in the course of their ordinary work. An appropriate disclosure. In order to make a PID, a person must have either an honest belief on reasonable grounds that wrongdoing has occurred, or have information which tends to show the wrongdoing, even if they don't have any belief about the wrongdoing. This is called the one or the other test. It is not necessary to have both, and one is not better than the other. It is an offence to intentionally make a false or misleading PID. There are two types of PIDs that can be made. Any person, including a public officer, can make a PID about substantial and specific danger to the health and safety of a person with a disability, or substantial and specific danger to the environment, where that is the result of the commission of an offence or failure to comply with a condition in certain pieces of legislation listed in the schedule to the PID Act, or reprisal action as a result of making a previous PID. In addition to the types of PID any person can make, public officers can also make PIDs about additional types of wrongdoing, namely corrupt conduct, maladministration that adversely affects a person's interests in a substantial and specific way, substantial misuse of public resources, substantial and specific danger to public health or safety, substantial and specific danger to the environment. To a proper authority. A PID must be made to the right place, referred to as a proper authority. The proper authority will differ depending upon the type of PID being made. This could include the entity to which the conduct relates, an entity with the power to investigate the disclosure, or any member of Parliament who are unable to investigate but can refer to the right place for further action. In limited circumstances, a PID can also be made to a journalist, and the disclosure still receives protection under the PID Act. Disclosures should get advice about whether they would be protected before they make a PID to a journalist. A key principle in the PID Act is protecting people from reprisal for disclosing information about wrongdoing. Reprisal means causing or attempting to cause detriment to someone because or in the belief they have made a PID. Example of reprisal action includes causing personal injury, damaging property, harming a person's reputation, bullying or harassing someone, or causing financial loss. The PID Act creates an offence of reprisal which can be investigated by an appropriate authority. There are a number of remedies that can be pursued, including a complaint to the Queensland Human Rights Commission, actions in the Queensland Industrial Relations Commission, or the District or Supreme Courts. Maintenance of confidentiality is vital to the protection of disclosures from reprisal. The PID Act defines certain information relating to PIDs as confidential. It makes it an offence to release that information except in certain circumstances, such as to investigate the PID or refer it to another proper authority. Disclosures are also protected if they breach codes of conduct or confidentiality provisions in legislation in order to make their PID, as the public interest in the information they disclose coming to light is considered to be more important from a public policy perspective. In addition, even if the allegations made in the PID are subsequently not found to be substantiated, the disclosure has a defence against any defamation proceeding. More information about PIDs is available by referring to your council's PID procedure, which should be published on your council's website. Your council's PID Coordinator, who is the person with responsibility for the management of PIDs, the Queensland Ombudsman website at www.ombudsman.qld.gov.au, which has a wide range of information and resources, the Queensland Ombudsman YouTube channel for information videos about PIDs, and finally the Crime and Corruption Commission website at www.ccc.qld.gov.au for information about corrupt conduct and a specific page about making a PID. To recap, you should now have useful information about the role of the Ombudsman, the Local Government Complaints Management Framework, the requirements in relation to human rights decision-making, and public interest disclosures. We encourage you to further your knowledge in these matters through the various resources referred to in this presentation. Finally, our office is available to assist further in several ways. Lodging a complaint or assisting a member of your community to further a complaint issue, assisting in the improvement of council administrative decision-making and capacity to manage complaints, lodging or seeking advice regarding public interest disclosures, the provision of training programs offered by this office, such as good decision-making, complaints management, dealing with conflicts of interest, practical ethics advice for state agencies and councils, managing public interest disclosures, and managing unreasonable complainant conduct. We hope that the information covered in this presentation has been useful. Please visit the Queensland Ombudsman website for further assistance.